This is Advocate Rehan Narula in front of you, and today we will be talking about a very important issue. That is, many of the taxpayers are asking me that, sir, we have received an order against us from the Commissioner GST, that is the first appellate authority. When we receive the order from the proper officer, we appeal to the commissioner level, right? And now here also we have received an adverse order. Now we are in full intention of filing the second appeal in the GST 80, but the problem is that we are not able to appeal because it has not been operational yet. That is the main issue here, right? The question which comes to their mind is that, can the department start recovery proceeding against us? This is the main question here. We will now be studying important case law in which, in the case of Archita soap and chemicals, in which the petitioner contended a circular, the circular number 224/18/2024, dated 11 July 2024, under the subject heading of Guidelines for Recovery of Outstanding Dues in cases where the first appeal has been disposed of. Right. So what happens here? This circular laid guidelines of the cases where the appeals has now been extinguished from the first appellate authority, and but they cannot file the appeal in the second appellate authority because it has not been operational yet in the section 112. Right. The petitioner submitted that the paragraph 4, which is prescribed in this particular circular, in which it has permitted the taxpayers that they should make a payment amount equal to the pre-deposit requirement, which is given in section 112 subsection 8. So what is happening here? I'll just give you a crux. In this particular case law and the circular, it states that the taxpayer now needs to deposit an extra 10% as per the requirement of section 112 subsection 8 in the electronic liability register by selecting that particular order number, right? And we will be paying additional 10% of the remaining tax amount. So in total we will be depositing 20%, right? Because 10% we gave in the first appellate proceedings, and now more of 10% of the remaining tax amount, and along with a declaration and undertaking to the jurisdictional officer of your local GST, we will be giving an undertaking in which you will be writing that we are depositing this particular tax amount, and we will be ready to file an appeal in the GST 80 as soon as it is operational, and we will be following all the legal time limits which are as per the rules and regulations, right? So this is the simple thing which a taxpayer can do. They can deposit the amount and automatically the proceedings will be stayed, right? So now this judgment and the circular is very helpful, as the people who are in full intention of getting their second appeal at the GST 80 can now wait and just deposit the 10% amount, the additional 10%, and can stay their proceedings, right? This is very helpful here. This particular circular and case law are very important. You can read the detailed newsletter in the description box. Thank you very much.